The Honourable Minister of State for Western Economic Diversification.
Thank you, Mr. Speaker. I'm pleased to rise today and speak on behalf of Bill S-4, the Digital Privacy Act, which was referred to the House by the Standing Committee on Industry, Science and Technology. When Parliament first enacted the Personal Information Protection and Electronic Documents Act, commonly known as PIPEDA, in 2001, it recognized that there are certain limited circumstances in which an individual's right to privacy must be balanced with other fundamental rights and public interests. One such interest is the need for investigations into breaches of agreements, contraventions of law, and for fraud prevention, which in certain circumstances must be conducted by the private sector. Examples of these are common, Mr. Speaker. They include investigations into professional misconduct by self-regulating professional associations, like the Provincial Colleges of Physicians and Surgeons, as well as the law societies. Another example is cross-sector investigations to detect crime and prevent fraud, such as the work done by the Bank Crime Prevention Centre and Investigation Office of the Canadian Bankers Association and the Investigative Services Division of the Insurance Bureau of Canada. It's not difficult to see, Mr. Speaker, that there is a real public interest in making sure that these organizations have the ability to investigate. In order to do so, they must be able to obtain personal information that is protected under PIPEDA. The Privacy Commissioner himself told the committee that, "I totally agree that there needs to be a provision in PIPEDA allowing organizations to address the issue of fraud or breaches of agreements that they may face. The need for such a provision is also recognized within the legal community." The committee heard from Eloise Graton, a leading privacy officer and partner at the law firm of Borden Ladner Gervais, and a professor of law at the University of Montreal. Ms. Graton spoke of her own experience as counsel to private organizations conducting investigations into wrongdoing. She said, and I quote, "Bottom line, I agree we need to have provisions authorizing the disclosure of personal information without consent to address these types of situations. And to enable this type of information sharing, PIPEDA currently has a regime that allows organizations to disclose an individual personal information in order to conduct certain types of investigations. And as it stands right now under the current law, investigators who want to access personal information must be listed as an investigative body in the regulations. This involves coming forward with an application to the government, and if the federal cabinet decides that the application is warranted, the organization is added to the list. This is an extremely burdensome process for organizations, and during the first parliamentary review of the Act in 2007, the Standing Committee on Access to Information, Privacy and Ethics recommended that this system be scrapped and replaced with a different set of rules based on those that have been in place for a decade in Alberta and British Columbia. So this bill implements this recommendation. A number of witnesses that came forward at the committee to express support for the importance of the changes within this bill expressed many positive sentiments in its regard. The Life and Health Insurance Association of Canada told the committee that these amendments would help the industry's effort to detect, deter, and minimize insurance fraud, which is stated to be extremely costly to the industry. A witness from this association explained to the committee that to committee members that there is a current gap in PIPEDA, to which he said, "It restricts the ability of organizations to disclose information without consent for the purpose of conducting an investigation into a breach of agreement or a law in Canada." And the Central Credit Union of Canada also testified that it supports the proposed exception for consent for fraud prevention. In the words of a credit union witness, "It will reduce the administrative burden associated with some of the activities of my organization's credit union office for crime prevention and investigation." And finally, Mr. Speaker, the Insurance Bureau of Canada also spoke to the importance of the proposed amendments for the investigation and prevention of automobile fraud. According to Insurance Bureau statistics, automobile fraud cost the Ontario economy an estimated $1.6 billion in 2014 alone. The witnesses from the Insurance Bureau explained in detail to the committee how Bill S-4 would make an insurance crime easier to detect and prevent as a result of the changes that our government is making. And this is great news. But I should note that during the committee's review of the bill, some concerns were expressed about the potential for misuse of such an exception to consent or resulting in the oversharing of personal information, as my colleagues opposite have noted today. But, Mr. Speaker, this bill protects against this particular aspect. Organizations can only make use of the exception to consent when a four-part test is met. First, the disclosure must be made to another private organization, not to the government or to law enforcement. Disclosure to government authorities must follow a different set of rules. For example, when a police must obtain a warrant to get private information. Second, the exception to consent is only available if the information is being shared for the purpose of conducting an investigation into a breach of Canadian law or a breach of an agreement, such as a contract, and it must be reasonable, Mr. Speaker. This means that an average Canadian must be able to see the merit of disclosing the information in question for the purposes of an investigation. And third, the investigation has to be legitimate. It must pertain to a contravention of law or a breach of agreement that has occurred, is occurring, or is imminent. Information can't simply be disclosed because an agreement might be broken. And finally, Mr. Speaker, it must be reasonable to believe that the seeking the consent of the individual in question to disclose the information would compromise the investigation, for example, by allowing them to destroy or alter evidence. It's the intention of this four-part test, Mr. Speaker, is to allow legitimate investigations that are in the public interest to take place in a manner that's being balanced with an individual's right to privacy. And of course, my colleagues have brought up the issue of copyright trolling. Certain concerns have been raised that copyright lawyers could abuse this amendment to target Canadian consumers. And let me be clear, Mr. Speaker, this type of activity is not an investigation, nor is it fraud prevention. Under no circumstances do we believe that this proposed amendment provides a backdoor that can be used for trolling due to these tests. PIPEDA has always provided a legal certainty with respect to the rights of legitimate private sector investigations, and Bill S-4 maintains that legal certainty, Mr. Speaker. I also want to touch upon a couple of comments that have been made in light of this bill. First is the definition of significant breach. There's been some doubt as to what this means. So per this bill, a significant breach is a breach that poses a real risk of significant harm based on the sensitivity of the personal information involved in the breach, the probability that the personal information has been, is being, or it will be misused, and any other factor prescribed in the regulations. And Mr. Speaker, significant harm, as has been brought up, is defined in Bill S-4 as bodily harm, humiliation, damage to reputation or relationships, loss of employment, business, or professional opportunities, financial loss, identity theft, negative effects on the credit record, or damage or loss to property. And in terms, again, because there is some doubt about private investigation, this is defined as an investigation carried out by private sector organizations, so not a government authority, into an alleged contravention of a Canadian law or an alleged breach of agreement. And Mr. Speaker, since we are getting to the end of this session of Parliament, should I not have an opportunity to rise again and debate in the next few weeks, I would like to thank all of my constituents in Calgary Centre North for the privilege of allowing me to serve them in the last 4 years, and as well as to my volunteer team, and certainly in a moment of nonpartisanship, to my colleagues across the aisle and in this House who every day travel away from their families, spend time in the honor of public service, Mr. Speaker. This isn't a job, this is service. And certainly when we all rise here and debate to discuss these issues, we might be passionate opponents one way or the other. I think we all do it to build a better Canada, Mr. Speaker. So it's a wonderful position to be in, to be able to rise and support bills like this, which are common sense measures to support, to make Canada a better place, to support better legislation, better privacy, better access to information, strengthening Canadian laws, and these are the things which as parliamentarians we're often seized with. So, Mr. Speaker, it's always a great pleasure to speak in this place. It's a great pleasure to be here as a parliamentarian, and thank you for this time.
Questions and comments? Questions et commentaires? L'honorable député de Chambly-Beaudoin.
Bien, merci, Monsieur le Président. Alors, merci à ma collègue pour son discours. La question que j'ai, c'est, évidemment, on a vu que la Cour suprême a statué récemment qu'on doit absolument avoir un mandat de la Cour pour pouvoir demander à une entreprise, que le gouvernement demande à une entreprise privée pour avoir de l'information sur leur vie privée. Et ce qu'on constate, et ce qui a été constaté en comité par plusieurs témoins, c'est qu'il n'y a rien dans le projet de loi qui oblige qu'il y ait des mandats de la part de la Cour. Donc, ça remet en question la constitutionnalité du projet de loi. Ce n'est pas quelque chose qui la préoccupe. Et si oui, est-ce qu'elle peut peut-être nous dire pourquoi le gouvernement n'a pas accepté aucun amendement à l'étape du comité, malgré, semble-t-il, la bonne volonté de leur part de vouloir procéder immédiatement à l'étude en comité?
L'honorable ministre d'État.
Mr. Speaker, as I mentioned in my speech, The changes in this bill affect private investigations, which, as the bill is defined, is an investigation carried out by a private sector organization, not a government authority. And Mr. Speaker, with regard to the Supreme Court decision, the Supreme Court itself noted that PIPEDA does not create any search and seizure powers for law enforcement. Instead, it allows companies to provide information to police should they choose to do so in circumstances where the police are, and here is the kicker, legally able to obtain the information. So, of course, through normal warranting procedures. The court has clearly stated that this is only when police have a warrant, are acting in exigent circumstances, are acting under an authority granted to them in the law, or are they obtaining information for which there is no reasonable expectation of privacy. And this decision, actually the Supreme Court decision itself, clarifies how PIPEDA works, and it does not mean how the Act or Bill S-4 need to change, Mr. Speaker. So, you know, I hope that my colleague will inform himself. I know he's well informed on his bill, and he knows certainly the ramifications of the Supreme Court ruling in this regard, and I hope that he would actually provide the correct information to his constituents and to folks abroad, that this indeed, as the member from Terrebonne mentioned, I have her quote here, but I believe, oh, here it is. The member from Terrebonne said, "We have been pushing for these measures, and I'm happy to see them introduced on April 8th, 2014. So certainly I think that this is something that supports all Canadians and is a common sense measure to help strengthen our legal system. Thank you.
Questions and comments? Questions et commentaires? Resuming debate. Oh, I'm sorry. Questions and comments? Honorable député de Honoré Mercier.
Merci, Monsieur le Président. Le 13 juin 2014, la Cour suprême du Canada a rendu une décision importante au sujet de la communication des renseignements personnels. Dans leur décision, les juges de la Cour suprême ont déclaré que les renseignements sur les abonnés, les noms, l'adresse, adresse courriel, numéro de téléphone, adresse IP, etc., ne peuvent être communiqués à une tierce partie sans mandat. Compte tenu de cette décision, ne croit pas la députée que la validité constitutionnelle de certaines dispositions du projet de loi S-4 semble douteuse? Merci, Monsieur le Président.
Fortunately, my colleague who just asked the exact same question off of their talking points that the lobby handed them, but I will, in fact, indulge the same response. In this bill refers to private investigations, with private investigations being defined as an investigation carried out by private sector organizations, so not a government authority. And the Supreme Court has noted, Mr. Speaker, so again, the Supreme Court itself, that PIPEDA does not create any search or seizure powers for law enforcement. So this bill relates to information sharing between private organizations in situations where such investigations are required to prevent fraud, law societies, insurance bureau. We heard testimony from this at committee, Mr. Speaker. The privacy commissioner himself put forward a comment saying that this change needed to be made. And again, referring back to the decision just so that she's perfectly clear, PIPEDA allows companies to provide information to police should they choose to do so in circumstances where the police are legally able to obtain the information. So of course, in terms of relating information to law enforcement officers as part of an investigation, warrants are most often required. What this bill does is ensure that there's information sharing provisions as part of an investigation between private organizations, Mr. Speaker.